Hello and welcome to the Vincent's October tax update. Been pretty quiet quarter post-election and over the winter break with Parliament, but I have done my best to find some exciting topics that we can go through today. Hopefully you'll be able to take something away from it. First up, quick message, standard disclaimer, information that will be provided today is not client specific. If you want to discuss anything further or obtain specific information in relation to your situation, please contact us directly. I didn't introduce myself. My name is Jenna. I'm a manager here at Vincent's. If you have any questions in relation to any of today's topics or would like further information, my contact details are on this slide. Feel free to email or give me a call. So the plan for today is, first of all, we'll go through a couple of ATO updates and reminders that have been released in the past quarter, follow that on with some new legislation and proposed legislation, as well as end with a couple of cases that I think might be of interest to a few of you. So starting out with ATO updates and reminders. So as part of the ATO's strategy to deal with the black economy, they're currently planning to visit around 10,000 businesses throughout Australia over this year to provide information on recent changes such as single touch payroll, the extension to the taxable payments reporting system, things like that. Industries they're likely going to be visiting as part of this process include cafes, restaurants, computer design systems related services, pharmaceutical stores and other kind of store-based retailing, creative and performing arts activities, residential building and construction, building cleaning, pest control, gardening services, and personal care type services. So keeping it close to home, last month, the ATO announced they'd be visiting 400 businesses in inner North Brisbane suburbs, Tenerife, New Farm, Newstead and Fortitude Valley throughout the month of October. Businesses that are being visited should have already been notified via letter, phone call, SMS or email. As part of their visits, the ATO plan on discussing record-keeping procedures, payment facilities, any outstanding lodgements, tax debts, things like that. Next, the ATO has updated its website and has collated a bunch of useful small business tools and services in one little convenient page. The link on the slide that I've provided here takes you to the supporting your small business page. Tools that can now be found in that one kind of stop include assistance in transitioning to the ATO online services, so the business portal, things like that. Access to the ATO app, which can be used to manage tax and super affairs, sets up reminders of due dates, payment dates, as well as allows sole traders to track things like income deductions, car trips, and other expenses. Also provides some useful information on managing debts, including payment plan estimates, how to set up payment plans should you be struggling to meet any of your payment obligations, as well as some other general tools that I think are of use are contractor decision tools, small business clearinghouse, and a heap of other learning resources. So it's definitely worth a look at. So next slide is on single touch payroll. I know this is a topic that was discussed in the prior quarter update in more detail, but given the small business registration date has just passed, I thought it was relevant to bring it up here again as a reminder. So as you'll be aware, single touch payroll sends tax and super data to the ATO directly. Large employers who had 20 or more employees had a registration date of 1 July 2018, so they should already be well underway in using the STP systems. Small employers and micro employers had a registration date of 30 September 2019, so it's only just passed. If you are a small employer who's not yet considered your STP registration requirements, I'd suggest you do so immediately. The tax office are allowing a year to transition, but it would be better to get on top of it now. Micro-employers, as I said, were required to register prior to 30 September 2019, but they do still have the option to report quarterly through a tax or BAS agent until 1 July 2021 if they satisfy the eligibility requirements to do so. If you're looking for more information in relation to single touch payroll, the ATO website is a useful place to start. I've included on this slide useful links to the single touch payroll in general, as well as the ATO links to a list of single touch payroll compliant providers and a list of low to no cost STP options. If you still have further questions, we have a number of people throughout the firm who can certainly help you out with any questions. Okay, this is another reminder of lodgements that were due. So the taxable payments annual reports for 2018 and 19 were due on the 28th of August. For those who don't know, these reports provide the ATO with additional information in relation to payments made to contractors to allow them to identify contractors who may not be including all of their income in tax returns or might not be meeting all of their GST lodgement obligations. So in prior years, the taxable payments annual reports only applied to businesses in the building and construction industry making payments to contractors. In 2019, this has been expanded to cleaning and courier services who also paid contractors to provide these cleaning and courier services on their behalf. Given the due date's already passed, I expect the ATO has already contacted businesses they believe now need to lodge under these obligations. But if you have any concerns, please don't hesitate to contact us. Important to note for future, in 2019-20 income tax year, there will introduce further industries into the taxable payments annual reporting obligations. These will include IT services, road freight services, security, investigation, and surveillance services. If your business is in one of these industries, you probably benefit now from checking whether you are potentially required to report and ensuring your current record-keeping practices are sufficient to meet the reporting requirements at year end. Will save you a lot of time if you're doing it now. Moving right along, the ATO recently released a reminder to taxpayers and tax professionals to pay close attention to the reporting of capital gains tax transactions. As the ATO's data matching capabilities around shares, property, cryptocurrencies increase, we expect we'll see a lot more attention in this area. If there are any kind of transactions that clients are doing in relation to purchases, sales, changes to CGT assets, please let your tax advisors know as soon as possible. That way we can be identifying the events and dealing with them as they occur. I'll also take the chance to add in a reminder that records are generally required to be kept for at least 5 years in relation to capital gains transactions. Okay, so moving right along, from 1 July 2019, new rules came into effect limiting deductions for payments to workers if PAYG withholding requirements have not been met. So while these changes won't impact the 2019 income tax returns we're currently preparing, they will apply to income tax returns lodged for the 2020 income tax year onwards. So the new measures will target payments such as salary, wages, commissions, bonuses, allowances, directors' fees, labour hire arrangements, things like that. So in order to claim a deduction, in the future, employers will need to make sure that they withhold the required amount before paying an employee, and also make sure they're reporting that amount to the ATO. Any payments made to a worker where an amount has not been withheld or reported will be considered a non-compliant payment, and a tax deduction will not be allowed. And the last of my little ATO updates and reminders is in relation to commercial debt forgiveness. So commercial debt forgiveness or CDF provisions apply where a creditor forgives a commercial debt owing to a debtor. The rules are in place to remove any tax benefit a taxpayer might obtain through an effective duplication of tax deductions that would otherwise arise from the forgiveness. There are certain exclusions to the operation of the CDF rules, one of which is the forgiveness made for reasons of natural love and affection. Now, previously, natural love and affection, not infection, sorry, was dealt with the ATO under ATO ID 2003-589. The ATO held the view that a company can forgive a debt owed by a natural person for reasons of natural love and affection and not trigger the consequences of the CDF provisions. This idea was actually withdrawn in February of this year, and last week the ATO released Draft Tax Determination 2019 D9, in which the Commissioner now takes the view that exclusions for debts forgiven for reasons of natural love and affection require that the creditor be a natural person. So this now means that the creditor cannot be a company or an individual acting in the capacity of a trustee. This withdrawal and introduction of the new draft is a complete 180 turn from the Commissioner's previously held views and means that a lot more thought is going to be required going forward where loans are forgiven within a family group. Moving on to some new and proposed law. So in September, the government reintroduced to Parliament its proposal for an amnesty to tackle non-payments of workers' superannuation. The Treasury Laws Amendment recovering unpaid super bill is currently before the House of Reps, and should it be passed, it will provide a one-off amnesty to encourage employers to self-correct any historical superannuation guarantee non-compliance. Should the bill pass without amendments, the amnesty period will begin from the 24th of May 2018 and will end 6 months after the bill receives royal assent. Employers taking advantage of the amnesty will be able to claim tax deductions for payments of super guarantee charge or contributions made during the amnesty period to offset the super guarantee charge, as well as pay reduced penalties and fees that may otherwise apply in relation to historical super guarantee non-compliance. The ATO have indicated that should the bill pass, employers who do not take advantage of the one-off amnesty will face significantly higher penalties if historical non-compliance is discovered. So next, avoid breaching concessional contributions caps. The Treasury Laws Amendment 2018 Super Measures No. 1 Bill received royal assent on the 2nd of October. The full range of changes and measures introduced in this bill will probably be discussed with Mike in the super update tomorrow, but I thought it worth mentioning here that the bill did include measures allowing eligible individuals with more than one employer who expect their employers' compulsory super contributions will exceed their concessional contributions cap in a given year to choose to nominate their wages from certain employers not be subject to the super guarantee rules. So while they will still need to receive super guarantee payments from at least one employer from 21 October 2019, eligible individuals will be able to use the application form on the ATO website to apply for the exemption up to 60 days before the period for which the exemption is sought. You can apply for multiple quarters within a financial year as part of the one exemption application. Once approved, the exemption certificate does not prevent the employer from actually making super contributions on behalf of the employee. It only means that the employer does not have to make super guarantee contributions to avoid the super guarantee charge. It's also important to note that if you're an individual applying for an exemption or an employer receiving an exemption certificate, that the certificate does not change an employer's obligations under a workplace award or agreement or an employer's agreement with their super fund. And then our last little area of some relevant case law that's come through in the past quarter. So Harding's case, this is again a topic that's been discussed in previous updates, but I'm going to mention it here again as the case has since been appealed to the full federal court, and they disagreed with the initial decision in the federal court. So, as a way of quick summary, Mr. Harding, taxpayer, departed Australia in 2009 and lived and worked in the Middle East, moving between fully furnished apartments in Bahrain while waiting for his wife and child to join him over there. The ATO initially assessed Mr. Harding on the basis that he was a tax resident of Australia in the years he was overseas, arguing that his domicile remained to be Australia. They argued this as he did not maintain a permanent place of abode outside of Australia due to the apartment accommodation in which he was residing being only temporary. As I alluded to earlier, the Commissioner's view was initially upheld by the federal court, a decision which Mr. Harding then appealed to the full federal court. Now, the full federal court disregarded the federal court's decision, ruling that a permanent place of abode should be interpreted more widely to consider whether a person is living permanently in a particular country or state, not just the permanence of a specific house, flat, or dwelling. So in this case, while Mr. Harding's accommodation in Bahrain may have been considered temporary or transitory, as he was looking to purchase large property once his family relocated and had taken further action towards settling his family in Bahrain, he'd therefore established a permanent place of abode outside of Australia. Since the full federal court decision, the Commissioner of Taxation has sought special leave to appeal the decision to the High Court, but this has been refused. What this decision means is a lot of expats working outside of Australia will certainly find it easier to meet the definition of a permanent place of abode outside of Australia moving forward. The last case I was going to have a look at today is slightly different than what we would usually discuss, but I think it's interesting nonetheless. So Glencore versus the Commissioner of Taxation. Story starts back in 2017 when there was a leak of approximately 13.4 million files from a law firm known as Appleby to the International Consortium of Investigative Journalists. The huge data dump, now known as the Paradise Papers, included details of hundreds of taxpayers being prominent individuals, multinational corporations, some of which were utilising a variety of secretive and complex tax schemes. The ATO obtained copies of these documents and began investigations into Glencore as a result. As the advice provided by Appleby was regarding the restructure of its Australian group, Glencore demanded the ATO return and not use the documents obtained through the Paradise Papers leak as they were subject to legal professional privilege. The ATO disagreed and we now have the following court case. So the key point following the decision in the High Court was that once a matter is in the public domain, in circumstances where the ATO was not in itself involved in securing the release or leak of the document, the ATO can and possibly should use the information as it is information in its possession. Should the ATO have been complicit in this release or leak of information? Different story. However, in this scenario, it can't be the case that the Paradise Papers are publicly available to everybody except the ATO to read, use, rely upon. So this decision raises some interesting issues in that while professional legal privilege is still a valid means by which to protect sensitive information, once the information makes it out to the public domain, there's little that can be done to bring it back. And that takes us to the end of our technical presentation for today. Just a little reminder here, Business Advisory is the team that I work with at Vincent's. Can help you out with any of your business, tax, super problems. And then we also offer a range of other services within the Vincent suite, lending services, insolvency and reconstruction, corporate advisory, all of which help us become a one-stop shop for all of your needs. So thank you for tuning in today. Again, if you have any questions or issues you'd like to discuss, don't hesitate to contact me on my contact details from the earlier slide. Thanks.